All right, everybody. Good evening, good evening, good evening, and welcome to Pushing Back Against Home Confinement, new reforms coming to electronic monitoring under the Pretrial Fairness Act. We are so excited that you are here to join us tonight. And this event is brought to you by the Coalition and Money Bond and the Illinois Network for Pretrial Justice. We are organizations based in Cook County and across Illinois that have fought together in partnership with members of our community, such as those of you watching tonight, to end money bond in Illinois. We are so excited because the Pretrial Fairness Act, which will make Illinois the first state to end money bond, was passed on January 1st of this year. And it is going to be going into full implementation in January 2023. And tonight we're talking about the elements of the law that will be going into effect in January 2022 pertaining to electronic monitoring. Electronic monitoring is really one of the biggest frontiers of pretrial justice and the movement for pretrial freedom that is facing our movement right now. And so we're really excited to talk to you all tonight about what are the problems with electronic monitoring, what are the changes coming to electronic monitoring, and how can we push back against this digital form of incarceration in 2022 and beyond. So you are in for a treat. To start, I'm going to talk a bit about electronic monitoring and give background, and then soon I will pass it to Akeisha, who will talk about the laws under the Pretrial Fairness Act pertaining to electronic monitoring, and then we will have an amazing panel really talking about how we are challenging this in the future of our movement. And so before we jump in, I just want to level set and explain what exactly is electronic monitoring. So electronic monitoring is a digital form of incarceration. It often uses surveillance tools such as ankle shackles to restrict and monitor people's movement and punish often their freedom of movement while they are on pretrial release or probation or parole or things of that nature. It is an alternative form of incarceration because when someone is on electronic monitoring, they are under the custody and power of the state, and the state does use its full force against people who are on electronic monitoring in similar ways to those who are in brick and mortar jails. And so electronic monitoring is a problem and it is destroying lives. And so I'm going to talk a little bit about why it needs to be abolished. And so our goal, the goal of our movement is really to fully abolish electronic monitoring. It is a form of incarceration. It is often touted as an alternative to incarceration, but is an alternative form of incarceration. It inflicts a lot of the same harms as incarceration. People's freedom of movement is restricted. Oftentimes, they might be confined to their homes. People are not able to do things like maintain employment, maintain education, take care of their families. Sometimes if you're on house arrest, you can't even help and take out the trash or take your kids to school. And so it imposes some of those same restrictions on people's freedom as are imposed when people are in brick and mortar jails. It inflicts all of this harm. It causes all of this anxiety without offering any corresponding benefit to our communities. It shifts kind of the cost of taking care of yourself to the person. The state is no longer providing any bedding, food, any of that like in jail, but instead you are responsible for yourself, but you're still taking on the same harms of incarceration. So essentially they're like, take care of yourself, but also we're going to restrict you in the same way that we would if you were in jail and unable to care for yourself. And it causes all of this harm without offering any benefit, and it actually costs millions of dollars of taxpayer money every year. Millions of dollars to run these programs, to employ staff, to monitor people, to surveil people, to punish people, when we know that these things do not actually help people to succeed while they're awaiting trial or in general. And it often makes their lives worse. And this money could be invested in things that are actually making our community safer. So it is our position that electronic monitoring is a form of incarceration that does need to be abolished. And so moving on, though, with the Pretrial Fairness Act, we had our sights set on ending wealth-based incarceration. So I guess the question would be, why didn't we abolish electronic monitoring with the Pretrial Fairness Act? The Pretrial Fairness Act had a primary goal of, can we go to the next slide, please? Sorry. Of ending wealth-based incarceration. And so this was a huge goal in and of itself. 5-6 years ago when this movement was first starting, people were told that it was impossible, that this was an unrealistic goal, that we should set our sights on something different. And so to get to the place where we were able to have policy passed to end money bond in our state was a huge lift, a huge accomplishment. But it would have been even more difficult to do that if we tried to abolish EM at the exact same time, because the system uses electronic monitoring as a crutch. And so if you're going to take away money bond and if you're going to limit pretrial incarceration, EM is one of those things that the system wants to lean on as the next go-to, as the next false alternative. And so if we tried to get rid of both of those things at the exact same time, we don't really think that we would have been able to get our policy passed. So what we tried to do instead was limit some of the worst harms of electronic monitoring and essentially take a harm reduction approach to this issue. And so what is the current landscape of EM in Illinois? In Illinois right now, electronic monitoring is pervasive in Cook County, and it is possibly expanding to other counties. One moment. Previous slide, please. It is pervasive in Cook County, and it is expanding to other counties. So right now in Cook County, there are 2 EM programs. One is run by the sheriff, and the other is run by the Office of the Chief Judge. And over those 2 programs, there are over 3,000 people on electronic monitoring. You know, prior to this moment, the overall number of people in the custody of the sheriff in pretrial, you know, in any form of pretrial surveillance or punishment was lower and decreasing. But because of expanding electronic monitoring, that number of the total number of people that are in jail or in digital incarceration combined has been going up because of the way that electronic monitoring has been expanding. During the height of the pandemic, that number got up over 4,000 people, and it's starting to level more, but it's still a ridiculous number of people on electronic monitoring. And our concern is that with the implementation of the Pretrial Fairness Act, that other counties may begin to try to implement electronic monitoring programs that don't currently have them. Because again, we know that the system looks at this as a crutch. Oh, we can't keep someone in a brick and mortar jail. Let's put them on EM. And so we are really trying to be vigilant against the expansion of electronic monitoring in our state, because we know that this is just a morphing of the same oppression that we've seen with pretrial incarceration and physical jails for all of these years. Next slide, please. And we know that this oppressive technology is not used equally against everyone. It is primarily targeted, like many aspects of the criminal legal system, against Black communities. If you look at the bar on the left, you will see that the proportion of people in Cook County who are Black is about 23%. And if you look on the right, you will see that about 74% of people who are on electronic monitoring are Black. And so this disproportionality is extreme. It's more extreme than differences in crime rates. It's more extreme than even differences in arrest rates. The disparity the racial disparity in terms of the use of electronic monitoring is incredibly acute. And it's also very place-based as well. So there are certain neighborhoods in Cook County that are really bearing the brunt of electronic monitoring, and other neighborhoods that have that feel no impact of it, that carry no burden of it. So some of our communities are really becoming open air prisons, and it is our Black communities. And so that's something that we have to really be mindful of when we're looking at how this technology is being used and who it's being used against. Next slide, please. And so one other thing that I want to point out before we move on to talking about some of the changes to EM is that there's been a skyrocketing number of incarceration for minor rule violations for people that are on electronic monitoring. And so under electronic monitoring, the sheriff has the right to oversee everyone's movement, to decide whether people are approved for movement to go places. And if they decide that someone has any form of violation of those rules, then they can be reincarcerated without even going before a judge, without that, alleged violation being validated in court, without really true due process. The sheriff can say, we think you broke this rule, you're going back to jail. And people can end up in jail for the pendency of their case because of an electronic monitoring violation. And this can mean weeks, months, or even years. And so this is a serious problem, and it's gotten even worse with the rise of people being incarcerated for technical violations on electronic monitoring. So if you look at this graph, you can see that the number of people that had their terms of EM ended, which means they were taken into jail for rule violations, that number has increased by 400% from 2020 to 2021. And this was without any increase in the actual number of people that are on electronic monitoring. This is just an increase in rule violations themselves and people being incarcerated for it. Over 500 people, over 500 families that are impacted by people being taken into jail for rule violations on EM. And what a lot of this can be attributed to is actually the technology that's being used. So prior to 2021, the technology that was used was just something that would basically indicate whether someone was inside their house or outside their house. And even that was inaccurate. Mohawk Johnson is someone who has spoken up publicly a lot about his experience sitting in his living room on EM and getting a call saying, you're out of compliance, you're out of your home. And we see video of him being right in his home. So the technology was already faulty before, when it was just telling whether someone was in their house or out their house. But now with GPS technology, it doesn't just track whether you're in your house or out your house. It tracks your every move, but inaccurately at that. And so, in previous cases, really GPS was used if someone was being asked not to be in a certain place. Like in a domestic violence case, if you were asked not to go to a certain place, that's where GPS would be used. But now GPS is being used in all cases. And so in all cases, you're not just people are being tracked their every location. And so if someone, has movement, for example, to go to work, but they stop at the grocery store on the way back, they can be taken into jail for that. If someone, if there is a technological error, which we hear about this, there's someone who said that their ankle shackles said they were in Lake Michigan, and that if it wasn't something so outrageous, they could have been taken to jail for that. We know someone at the bond fund who, the thing was, how GPS will bounce around and say you're in different places where you're not. It was saying that someone was in multiple locations that they couldn't have been in the same time frame, but they were punished and taken into jail for that. So this technology is faulty. And at the same time, the solution is not better technology. The solution is that we need to stop trying to incarcerate people digitally using this form of technology. And so as we aim to push back against this really harmful form of electronic incarceration, I'm going to pass it to Akeisha to really talk about what are the changes that are coming to the electronic monitoring laws under the Pretrial Fairness Act in January of 2022.
Thanks, Brianna. Hi, everyone. My name is Akeisha Lee. I am the lead organizer for Southsiders Organized for Union Liberation, also known as SOUL, and my pronouns are she, her, and hers. And today I will be talking about the new EM laws under the Pretrial Fairness Act. So there are 4 key changes to EM under the Pretrial Fairness Act. Those are guaranteed movement, mandatory 60-day review of EM orders, guarantees of sentence credit, and it makes it harder to file escape charges. Next slide, please. So guaranteed movement, under the current system, there is no requirement that judges grant anyone any movement. As Brianna said earlier, a lot of folks are underneath the Sheriff's Department EM. Underneath that system, people are, by and large, in their homes for 24 hours a day, 7 days a week. And this is not lifted for things like buying groceries, going to the pharmacy, taking care of your children, and movement can be denied for any reason at all. So after January 1 of next year, judges will be required to allow movement on at least 2 days a week, and movement must be given for basic necessities. So people will be allowed to apply for this additional movement and should be granted movement on top of what they already received for work. Once the movement is granted, they will be able to do things like shop for groceries, take care of their children, and other activities that folks do who are legally innocent under the law. Next slide, please. Okay, so there'll be a mandatory review of EM orders after 60 days. So under the current system, there is no requirement that judges revisit EM incarceration during the pretrial case. And people can be doing these pretrial cases from anywhere from like a couple of days to years. So people stay on EM for a very long time under the current system, with 78% people who are in EM under Cook County being there for at least 3 months. So under the new law next year, EM orders will be reviewed every 60 days. And EM can only be continued if it's the only way to ensure appearance in court or to protect a specific person from imminent harm. So what does that mean? Research shows us that EM does not change the rate at which people appear in court or are compliant with other court-specific things. And our hope is that under this new system, it will be rare for EM to be assigned and that it will be almost unheard of people to be on EM for more than 60 days if judges follow this new law. Next slide. Okay, so guaranteed sentence credit. First, just to define that, sentencing credits reduce a person's sentence either based on time spent in custody before conviction or by earning credits for good behavior after conviction. A credit is a period of time usually expressed in days, which will be subtracted from the sentence the person received for the conviction. So under the current system, some judges give credit for EM and some just don't. There's not really rhyme or reason. There's no way to ensure they will. But under the new law, all EM must be counted as incarceration credit because before this is incarceration. And the law is specific that you don't have to be on EM band or under 24-hour house arrest. As long as you're confined to your home for and restricted of your liberty, you would be eligible for this new credit. Next slide. And last, it would be harder to file escape charges. So escape charges are remnants from people being in brick and mortar jails where they are accused of escaping the jail and they are remaining in our current system under EM. So a person can be filed for escape charges for any violation of rules under EM. And these charges hold a class 3 felony, meaning that they can be in jail for 2 to 5 years on top of whatever sentence they had originally that placed them on EM. So even if your first charge is dropped, your escape charge can still proceed, right? And this happens. Like I heard a story recently from a colleague where someone's charge was dropped. They were actually found innocent of the charge and they were still incarcerated and put on probation for 2 to 5 years because this still stands because of violations. So after the next year, people could only be suspects for file for escape charges if someone remains in violation for 48 hours or more. Next slide. So in talking about all these changes, how can someone actually benefit? So a person needs to contact their attorney and file a petition to modify electronic monitoring. And then the public defenders are going to get a training within their offices so they know how to apply these new changes. And I'm going to pass it back to Brianna. Thanks, y'all.
Thank you so much, Akeisha. So we know that was a lot of information. If you all have any questions, feel free to drop them in the chat. One of our policy colleagues are on standby, ready to answer any questions that you all may have. We know some people are really excited and awaiting these changes going into effect, and we want to make sure that you have all the information that you need. So that concludes the first portion of our program, and I am really excited to introduce the panelists and moderator for the next portion of our program on pushing back against home confinement. I will first introduce our moderator, our public defender, Sharone Mitchell Jr. I will be moderating tonight's conversation on where the movement is going to push back against home confinement. Next, we will have Maya Schenwar. She is editor-in-chief of Prison by Any Other Name. Well, she's editor-in-chief of Truthout, and she's author of Prison by Any Other Name. And last but not least, well, not last but not least, second to last but not least, we have Colette Payne, who is the director of the Reclamation Justice Project at the Women's Justice Institute. And last but not least, we have Amy Thompson, who is the Deputy of Central Operations at the Public Defender's Office. So we have a powerhouse lined up tonight for a great conversation, and we're going to pass it over to them. Thanks, everyone.
Hey, y'all. My name is Sharone Mitchell Jr. I am so incredibly excited. I cannot tell you how excited I am because we have here, I think, 3 of just incredible experts on the issues of liberation and the criminal legal system. I'm hoping that I don't blow this, because if I don't, this is going to be an incredible conversation. Maya, Colette, and Amy, thank you so much for sitting down with the coalition and talking a little bit about this issue.
Thanks, Sharone.
Let me open it up. I'm gonna, we sent some questions, but I really wanted this to be a conversation, and we're hoping we're gonna get there. I'm gonna go off the top here. I apologize. I'm already going off script. I spent some time, lobbying and talking to people about, reform or abolition or just changing the legal system for the better. And this is what I hear. Listen, it's better than jail. It's better than prison. You get an opportunity to get out of a prison or a jail where there's COVID and there's all types of harm. Why are y'all complaining about electronic monitoring? Who wants to take that?
I can start. Being a person who has been on electronic monitoring, I mean, like way before they had the ankle bracelets, they had it for your wrist. And I was mandated by a judge, and it was a little different than it is now. Kind of telling my age, right? But I couldn't even take out the garbage. I couldn't go 100 feet from my door, and that's where the dumpster was. I couldn't take my children to school. They were young at the time, and their school was right across the street. I couldn't participate in no activities. Taking them to the school, walking them to the grocery store, which is right up the street, to get a juice or, get a gallon of milk, get some formula. My children were really young then. And now, today, it's even worse. My son, who recently passed, he had did his time on electronic monitoring. He did a year on EM. And, he went to prison as a turnaround. So he dressed in and dressed out, which I didn't understand that. So now you would say he's free on probation, right? My son ended up being shot. And when he got shot, went to the doctor, came to my home to recuperate, build his strength. Here comes the parole agent and says, we're putting you on electronic monitoring. He wasn't on it at first. I couldn't understand it. I said, and I'm at work at the time. So when he calls me and say, Ma, they're here. They're threatening me. They're telling me I can remove you from this home. So he had a doctor's appointment. He had a bullet lodged in his testicle. We couldn't even get movement. None at all. This bullet could have possibly traveled to somewhere else and possibly killed him. They didn't want to remove the bullet because that would have been a problem, and I just did what I had to do. And I told them, look, I'm taking my son to his appointments, no matter what he's going. So electronic monitoring can be a problem for many, especially if you have a job.
I want to say, I think that besides just making your home part of the prison, it also includes all of your family members in your incarceration. People who aren't even accused or alleged to have done any criminal activity are now being very seriously surveyed by the technology that's being used by the sheriff's department. The sheriff's department moved to a technology called the track group bracelet. And that bracelet has a two-way radio that they can turn on as a listening device in the homes of people who are only accused of crimes that there has been no evidence put forward. And every person that comes into that home is subject to that potential listening device. So now we've taken communities that we've already underserved and oversurveyed, and we've done even further by putting a listening device in the homes of people who aren't even accused of any crimes. And to me, that takes it so far beyond even incarceration, because as bad as incarcerating people pretrial is, what we've done as a society is say, we will watch every person that comes in contact with anyone we accuse of wrongdoing. And we know who gets accused.
Yeah, absolutely. And I'm thinking about how when my co-author Vicky and I were writing our book, we interviewed a person and her family she was on EM actually for several years. And her husband spoke about EM as a home invasion by authorities. And I thought that was a really, really apt way to put it. And my sister was on electronic monitoring. And during that time, she would call me pleading for me to bring her basic things, groceries, Band-Aids. She was scared of going to the doctor. That's a common theme that came up among a lot of people. including at the beginning of COVID, like, what do? You're making a choice between going to the emergency room and potentially risking ending up right back in a COVID-filled jail, or staying at home and being really sick, so giving people those kinds of impossible choices. And I also want to point out, of course, a lot of people given the option will choose EM, and that doesn't mean that EM is okay. Our choices should not be a cage or a different kind of cage. Like, why do our imaginations have to be so limited? And I think another thing that comes to mind when people pose this kind of false alternative is that EM is actually, like so many of these other alternatives that we see, an avenue for expansion. So EM comes into the picture, and a lot of people end up in these digital forms of incarceration who would not otherwise be under physical control of the state, who might not otherwise be in jail. And so it's posed as an alternative, a replacement, whatever, but actually ends up being a vast expansion.
Right, that's a great point. And I'm going to come to you, Amy, right now. Colette used the term. She used a term called movement. And I think many people kind of think of, okay, I'm on this quote unquote bracelet, right? And we use the word bracelet, which is incredibly problematic, right? I'm on this bracelet, but I can move about the world as I see fit, and I can live my life. And Colette talked a little bit about that being wrong, but Amy is a person who's been trying these cases for a number of years and who manages literally over hundreds of attorneys. Tell me a little bit about what movement means, right? And what limitations a person in Cook County would normally face if they are on electronic monitoring.
When you're on electronic monitoring, movement means your ability to leave the physical barrier of your home for any purpose at any time. There are orders that are in place by the judge that allow some people to have movement. Colette talked about people who have jobs. Some judges allow some people to go to work at a very specific time and a very specific place as an order, a condition of their release on electronic monitoring. We just got the numbers of how many people have zero movement orders, and it's over 1,600 people have zero movement, meaning according to their order, they're not allowed to step foot out of their house at any time, 7 days a week, 24 hours a day. So when somebody needs movement, for instance, somebody's mother or father dies, or somebody's mother or father is sick, they can't visit the hospital, they can't attend funeral services without specific permission from the sheriff's department in most cases. I just want to say the pretrial services electronic monitoring is a completely different system. So I'm really talking mostly about the sheriff's department. But with the sheriff's department, there's only one phone number, and only the person on electronic monitoring is allowed to call that number and make an initial request. That number is just like any other service number that you would come across. The chance of somebody answering it when you call from your home phone on the first try is almost nothing. And when you do get through, the first thing you have to do is make a request that is specifically meets the requirements of their service, which isn't spelled out to you in any way or any way made transparent to you about what has to be in that request. When you call your lawyer, which is what you should do in most circumstances, they won't accept a call from your lawyer with a specific request. They won't even accept it or write it in the book. They insist it has to come from the person on electronic monitoring.
Amy, could you give me that number one more time? What's that number?
I just, right off the top of my head, I don't know the number, but there's only one.
No. The number that you said, the amount of people who
have 1,600. Over 1,600 with zero movement.
And Colette, when I that number hit me like it hit you, you just started shaking your head. 24 hours a day, 7 days a week, no movement. Tell me what that means to you.
You're in prison. I mean, it's just like prison, and you're confined to your own home. Your family is confined to the home as well. So I'm gonna give some examples. What if I need to get food stamps to assist with feeding myself and my family? I can't do that. What if I say, okay, I want to do something different with my life. I want to go to school. You can't even do that. Like, I think about even after a person has an arrest or a conviction and the permanent punishments that come behind that. It's like we're in a no-win situation. Either we're damned if we do or we're damned if we don't. So how do we win here? Where's the level playing field where people can do more than just exist in our communities? We need to be thriving, and not just surviving. And we can't do that when we're confined to our homes or confined to jails. How are we looking and investing, looking at people's lives, building? And I know this may be hard and it seems, but community is about relationships. How are we understanding where it is that people are at in their lives and meeting them where they're at? The only thing that is looked at is the charge. Nothing else. This charge. We're not a human being. We don't have children. We don't want to get a job. We don't want to better ourselves. We don't want to stop using substances. I used substances for many years. Even for somebody who gets out on electronic monitoring and they have a substance use disorder. Heroin, crack cocaine. That's where I come from. Of course, I'm gonna say, yay, I want this. But I might have dried out a little bit, but mentally I'm not ready. Physically, I'm still dope sick. And I have to feed my body. And then when you talk about treatment that's coercive, the approach is always the same.
I talk a little bit about that treatment piece.
Yeah, I mean, I think that I'm really glad you brought that in, Colette, because I think that EM is not the only alternative, and it's not the only form of coercion that we see coming down from courts and even being posed as an alternative to incarceration. And so treatment, court-mandated treatment, the kinds of treatment that are not voluntary, all of those things are also forms of control and in some cases confinement. We see a lot of drug treatment centers looking quite a bit like prison. And I think that this is something like, as we think through, well, what are the liberatory paths forward? Like, what are the things that we can provide? I think we always have to be asking ourselves that question along the way. Is this coercion? Is this control? Is this confinement? And if not, like, let's explore what it's actually doing. I mentioned my sister was on electronic monitoring, and actually at the time that she died, she was in a drug court program, so a form of court mandated treatment that was forcing her to be sober, be abstinent from all drugs. And she left the program, escaped the program, and went back to using heroin, and her tolerance had lowered under this coercive abstinence-based program. And so she died the first time she used. And so I think we really have to dig deep and question these mandates, question the ways we take away people's autonomy over their bodies and their minds, with the assumption, because it's so built into us in this society, that the only way to support people is to come from above and put these controls on them because people don't know what they're doing or, won't make the right choices for themselves. Well, that hasn't worked. That process and that system and that mindset is killing people all the time. And so we need to expand and our imaginations and dream differently.
Yeah, I think coercion is it's a tie that binds throughout the entire, criminal legal system. It's something that we see throughout, whether we're talking about plea bargains, whether we're talking about the decision to take on electronic monitoring, right? We have this, I think, conception that the legal system is about kind of two sides coming together to fact find and the truth will come out. And in reality, that process, right, rarely happens because the system is built to force an accused person, right, to essentially plead guilty, right? And it is only folks having to do kind of go over and beyond to break that cycle, right? It's a really, really unfortunate system. You know, Amy, you talked a little bit about what we see here in Cook County, and you described a kind of a process where both people can listen in, right, to a conversation when somebody's on electronic monitoring. You've also described a process in which people have to kind of call into a number. You're kind of seeing a privatization of incarceration, right? People kind of think about private prisons, and they think of, I think liberals and good progressives can understand that private prisons are bad, but that thinking is very myopic, right? This is a process we're seeing here in Cook County where you see the privatization of incarceration, but incarceration of people. I'm not a fan of incarceration, but even incarceration of people who have not been found guilty or had any evidence presented against them.
That's right. And when the sheriffs went to the track group, they basically signed a contract with a private vendor that helps them not only monitor people in their homes, which they've claimed they don't do, but when the claim was made before in Puerto Rico, the forensic evidence showed that the very monitor that is being used now can listen in 100%, 24 hours a day without giving any signal to the person that they're being listened to. The website of the track group, which I encourage anyone to go and look up, even says that their own system will allow for 24 hours of listening with an automatic transcription of the conversations that are overheard. And they also outsource some of the enforcement of the violations, which is very, very frightening because the people that they're outsourcing it to don't have any conception of what the GPS actually means. They aren't trained to read or understand if the system or the technology is working. They are a call center that is based, as far as I can tell for sure, outside of the state of Illinois, let alone outside of Cook County. And they don't understand how the technology really speaks back to them. They have codes that they know, and they file the violations that are sent to the state's attorney's office.
Talk a little bit about that process, though, for folks who aren't attorneys, who aren't kind of in the process. When you say somebody's violated, that mean that's just like a mark on their record? And, what does a violation mean?
What a violation in Cook County of the sheriff's program means most often is that if somebody is seen to have left the position that they are supposed to be in, according to the GPS as it exists, a violation can be filed and they can be pulled in off their homes back into Cook County Jail. And then the violation is brought before the judge. That could happen 2 or 3 days after, but even if that happens at all right away, the judge has only the information given to them by the sheriff's department that's given to them by this vendor about what happened that created the violation. And as the hosts earlier were talking about, as Brianna and as they were saying, there's no real test for us about what's true about this GPS. It's taken as true. But there is no background for us to believe that what they're saying is true. So even if the process of incarcerating someone at their home with a monitor that tells you where they are was a good process, that's not the process that's being followed, because the GPS hasn't been proven to be accurate, and yet it's taken as truth in court.
Colette, you have an incredible amount of experience advocating for changes to the legal system, lobbying for changes to the legal system. You served as an organizer and policy advocate at Cabrini Green Legal Aid. You now are the director of the Reclamation Project at the Women's Justice Institute. Tell me how reforms like this, because this is like, this is presented as a reform, how do they stick, right? Like, how do we get to a process where things like this are seen as like an attractive option for our system?
Oh, so, people think that, of course, being in your home, confined in your home and not in prison is better. I remember when I first started doing this work, and I started working with Chicago Legal Advocacy for Incarcerated Mothers. And we would work specifically on women's issues. And, that was one thing we would say: alternatives to incarceration, electronic monitoring, or sentence to treatment for an alternative. But, as years started to change, the work started to evolve. You had more people coming into the space with lived experience to share their experience. People began to understand what it was and what it is that we were experiencing or had experienced. So, it takes, like, when Chicago Community Bond Fund started, like, it opened up they were hearing stories, getting people out. People were able to share their all and their everything. And I think, sharing stories is important.
Yeah.
It changes, it hopefully is changing hearts and minds. And is educating communities on what really happens and how it happens. But it's going to take, with any law that is passed, implementation to ensure that things are being done correctly.
Yeah. I think I was so glad to hear you say that about the way in which movement spaces and advocacy spaces evolved and changed in the direction of actually questioning EM. And I remember, so I was part of the founding of the Chicago Community Bond Fund. And I remember these conversations that we had at the beginning. We were starting to piece together, okay, as we advocate for changes to anything pretrial, especially the abolition of money bond, they're just going to say EM. Okay, great, EM. And this was one of the predictions that surfaced, and it panned out that way, which you can almost, like, it's almost a given that it would, because people replace cages with cages unless they're really pushed not to. But I think what you mentioned is this really encouraging thing that when people tell stories, when people are getting out, when those stories are lifted up, we're painting the picture of the reality of what's actually happening. And the stories and that broader, more detailed picture kind of lay plain the fact that this is not an alternative. It's not the next best thing. It's not that simple.
I got three things that we want to hit. We got like 9 minutes. I don't know if we're going to be able to get it done, but let's give it a try. Lived experience. I want to talk a little bit about that, because I think you talked a lot about it, Colette, but this is kind of taking a step out of the EM space, and we're going to get back into it. But to me, folks in offices like these, right, can come up with solutions, right? And the solutions can make sense to us, And we can be really well-meaning people, right, that are trying to do the right thing, right? But when you've lived it, right, you bring an entirely different perspective, right, to the problem, and you can craft those solutions. How, as a community, can we benefit from that more? What can we do to continue to reap the benefits of folks who have lived that, walked through those shoes, like walked in that path, walked in those shoes? How can we be better?
So, it's only a few of us with lived experiences in these spaces, policy spaces, that are, changing laws, educating people on things. If organizations would hire more folks with lived experience, we're the ambassadors. We come from those communities. We go out into those communities. We build relationships with folks, other folks who may not understand, hey, you can get on board and do this. And it's power in numbers. It's power in numbers. You got power people with money, but it's power with numbers too. It takes organizing, education, but it also takes listening to what folks need. So even outside of having an arrest or a conviction or having used substances or being on EM, you think about, what does that person need? What did they need before this charge even happened? We don't take into account what people need. It's like, if we redirect those dollars, what is reinvestment? When you abolish something, you reinvest that back into the community and provide resources for people. And one of those resources is hiring a person with lived experience to do the work.
Absolutely. Colette, you talked about power in numbers. You talked about folks being able to change the conversation. I'm going to try to kind of draw this line to the implementation. Amy has been on the front lines of implementing these changes, right? People outside of the traditional legal system, kind of really, I think, were the catalyst for the changes we've seen in the Pretrial Fairness Act, right? These changes certainly were assisted by people who were insiders, right? But they would not have existed, both in their creation and actually getting across the finish line, if it weren't for people on the outside, right, who said this is the right thing to do. Because people on the inside can kind of we have this tunnel vision, like we have a vision of like what's possible, and our conception of what's possible is only defined about those kind of myopic experiences, right, that we've gone through. So Amy, talk about that process, right, of taking something that essentially came from the outside and trying to install it into a place like the criminal legal system, the Cook County criminal legal system, that sometimes can lack creativity.
Yeah, I'll tell you that when I first heard about the abolition of cash bail, I thought it was a pipe dream. And I've been in the public defender's office for 30 years. And I thought that one of the things that those of us who are inside the institutions, one of the things that we have to be reminded of all the time is that we are not responsible to change people. We don't have the power, and that's not what the legal system does. It doesn't change people. We need to really recognize, and what we do learn from people with lived experience that now we have a lot more exposure to, thank God, is that what we need to do is change the circumstances, the opportunity, allow for communities, and that changes your entire perspective on how to implement things, right? If I'm not trying to change people that come into the system against their will and by whatever enforcement the people inside the system choose, and instead I try to uplift communities and create opportunities for communities, then I'm not looking for cages. And then when I'm not looking for cages and I'm talking to other people in the system who are used to like thinking of the system as this side of the bars or that side of the bars, And I change it to see about the fact that the people that are coming in have a right to belong to a community, and that community should be the center of our goals. It's easy to change the way it's implemented because the people want that. It's so much more hopeful for those of us inside the system to have that to look at and to really see it as a goal, that it makes it a lot easier for us to not only accept change, but embrace it.
Maya, talk a little bit about the national perspective, right? I think in Cook County, we kind of think Cook County is so, unique. Things that are happening in Cook County don't exist anywhere else. But you spent a lot of time studying just not what's happening here and having conversations with people here, but people across the state and nationally. Could you talk a little bit about kind of the significant rise in work of EM, surveillance, technology, and really how people are really trying to resist that movement?
Yeah, absolutely. So the numbers of people on pretrial EM in counties around the country have shot up. It's not just here. And unfortunately, there's not great nationwide data on electronic monitoring, although it's getting better thanks to some grassroots efforts. But even when we look at limited examples, we see Harris County, Texas, where Houston is, where the population on EM shot up from, I think it was 27 people in 2019 to over 4,000 people in October of this year. In LA, pretrial electronic monitoring increased something like 5,000%, 5,500% since 2015. And so this is something that's happening everywhere for many of the same reasons that it's happening in Chicago. And I also want to note that ICE has increasingly been using electronic monitoring as well. And the numbers there have also completely shot up, like some of the really drastic numbers around that too. But in the same way that wherever there's oppression, wherever there's violence, people are pushing back. That's happening in terms of EM. And of course, right here in Chicago with the Coalition and the Bond Fund and Soul and other organizations. I also, nationwide and also here in Illinois, I would really like to draw attention to the Challenging E-Carceration project, which is housed at Media Justice. But this is spearheaded by James Kilgore, who has done some of the most powerful work on this issue and has really pushed campaigns forward that are both looking to abolish EM and recognize that it's a form of incarceration, and also to think about, okay, what are the ways to reduce harm? Always simultaneously saying, the goal is abolition. So I would definitely encourage everybody to look at James Kilgore's work, to look at the work of Mi Gente and Just Futures Law, who are pushing back against EM within the immigration system and ICE. And I think that we can see how all of this work intersects. All of these groups have been working in coalition. Groups in California, like All of Us or None, have spoken out against the harms of EM. So this is something that is a growing coalitional movement. And there are all kinds of groups coming together who work on other things, but have noticed that EM touches their work and is causing harm in their communities. So this is a rising, rapidly growing movement.
I think we're going to end the panel there because we really can't do it anymore. That was such a great overview of what's happening nationally. It's so good to know that we are not alone and there are people outside of our little gamut that are continuing to fight. That fellowship to me is so incredibly inspiring. I want to thank, I'm the luckiest person in the world because I got to be in conversation. I get to ask whatever questions I wanted to with three amazing leaders, Maya, Colette, Amy. Thank you so much. Also, shout out to the folks in the chat. Sarah's doing a great job. answering questions. If there's some more questions, the coalition is always around to answer things we've got going on. We're going to kick it back over to Bree from the Bond Fund, who is going to close out the event. Shout out to the woman behind the boards, my homie Co. Love you, Co, for making this thing go so smooth. Bree, thank you so much. Take us away.
Yes, thank you, Sharone, and thank you to all of our amazing panelists. That conversation was just packed with gems, from intersections with EM and coercive treatment, to immigration, to money bond, and this broader push for pretrial freedom. This was just really robust and rich. And so we're so grateful to you all for your perspective and time tonight. One of the things that that Amy said that I thought was really, really important to remember was that, like, it's not our job to try to change people. And what happens is this system tries to punish people into progress. And you cannot punish people into progress. Like, that is not how we work. And when people are given the resources and opportunities that they need to thrive, they will. And so what Colette said about what did somebody need before the charge, that's the question that we need to be asking, is what was needed before the charge. And so one of the things that we know people need in order to progress and to thrive is freedom. And so that's what we're going to continue to fight for. And we did that with the abolition of money bond, the pipe dream come true, as Amy called it. And what we have to do now is fight to defend that victory. And so what I want to invite everybody watching to do is to register for some text banking sessions that we're going to have in January and the new year to really keep the momentum going. Because what happens whenever our movement makes progress? Whenever our movement makes progress, opposition wants to swing the pendulum in the opposite direction. And that's some of what we're seeing in Springfield, is people wanting to push for tough on crime laws and things of that nature, almost as a reaction to the progress that we're making in our movement. And so we have to keep the pressure up. We want to keep letting the legislature know that we are watching, that we are holding them accountable to push for freedom, not for surveillance, not for punishment, because freedom begets more freedom, and punishment only brings more pain. And so thank you all for checking out that link, registering in the chat, and we will see you in the new year as we march into these new changes to electronic monitoring, and we continue to push back in 2022 and beyond. Thank you.